Okay, so my name is Kristen Devaney. I am a family law and matrimonial law attorney with Shapiro Ford. I've been with this firm for about 5.5 years, almost 6 years. Prior to this firm, I worked for a different matrimonial and family law firm for about 3 to 4 years. So I have been doing, and before that I was in law school. So I've been doing this field essentially since I've been admitted to the bar. I haven't really done anything else. I do some estate work, but very non-contested estate work, just probating a will or something like that I can do. But I mostly focus on matrimonial family law, and I do adoption, something that I really enjoy doing. And I'm trying to always look for more clients who are looking to do adoptions. A little bit about my background. I grew up in Massachusetts. Most of my family is there. I'm the oldest of 6 kids. And I went to college at Dartmouth in New Hampshire. I went there wanting to pursue journalism, and I studied English. That was my major for a couple of years. I loved writing. I still love writing. It's my favorite part about this job is doing motion work, which a lot of attorneys can't stand, but I really don't get sick of it. And I genuinely really almost to a fault, get enveloped in all of the research that can just be nonstop and putting an argument into a motion. And I really I pride myself in the written work that I submit to the court. So I studied English for a couple of years, and then wanting to pursue journalism, like I said, I joined the school newspaper. And almost immediately I got very frustrated with the angles that I was required to write stories. And I'm so glad that I decided I added government to my major and decided to pursue law school. And I'm so glad looking back that I did not pursue journalism, given, on both sides, how the media portrays. I never know what's going on with the media, the way that they portray certain facts. And so I'm really glad that I chose this field rather than going into journalism, because I think that even the small window that I had with respect to taking things with a particular angle would have been very frustrating as a career for me. So I went to law. First of all, I worked for Dewey and LaBeouf, which started out as LaBeouf, Lamb, Green, and McRae is where I started, and then it merged with Dewey and LaBeouf. And that firm, I don't know if you guys have heard of it, but it went bankrupt, went down the tubes as I was getting out, thank goodness, right around the crash. And I went to law school after that. In DC, I went to Catholic University School of Law and loved it there. I loved DC and came back up here to practice family and matrimonial law. In law school, I did some clinics with respect to family law. Really enjoyed it. Felt like I could really make a difference in individuals and people's real lives. I enjoyed dealing with clientele, and it's something that I chose to pursue, and I haven't left. So it's not always a thankful type of job, but my goal is always to get people to the finish line. This is one of the most difficult, if not the most difficult time in people's lives. People are very vulnerable. They're very emotional. And my goal is to get them to the end line. And I really, really genuinely like the feeling of them signing an agreement and saying, I feel like this is a new chapter. And it gets better. Once this stage is done, for the most part, it gets better for them, and they're back on their feet. And even the relationship with the other spouse, as tumultuous as it could be during the litigation, gets better, or at least workable. So that's a little bit about my background and why I'm in this profession. I wanted to go through the main topics of a divorce, and then at the end of each topic, kind of hone in on how the pandemic, in my perspective, have affected these types of cases. So the four main broad topics in a divorce, as I explain it to somebody in a consult, is custody and parenting time, child support, maintenance, and equitable distribution of the assets. There's a fifth one that isn't really dealt with anymore called grounds, and the grounds is the basis for the divorce. In 2010, the law changed in New York to allow for irretrievable breakdown of the marriage. So rather than needing to prove adultery or cruel and inhuman treatment as a grounds for divorce, the law said that you can just assert that so long as the relationship is broken down for a period of at least 6 months, you're entitled to a divorce. You don't need to prove any grounds. That's sometimes hard for people who have grounds to understand. They want to plead the reasons behind the divorce, but it honestly makes no difference to the court and to the law on how we're going to deal with custody, on how we're going to deal with support, on how we're going to distribute the assets. And so it's hard for some people to wrap their mind around that concept because they want the adultery exposed, right? But it ultimately doesn't make a difference. And to try a case based on grounds is not something that a judge these days really wants to deal with. And the reason for that is because if you're spending all of this time and all of this money just fighting over the ability to get a divorce based on certain grounds that you have to prove with witnesses and evidence and whatever else, you haven't even gotten to resolving the terms of the divorce. And so that's why they took away the grounds aspect, because they just want to get people to the end here. And I understand where people are coming from, but it's just not worth the fighting about why you're getting divorced, because the judges just don't want to deal with it anymore, especially since the law changed. Okay, so going forward, custody and parenting time. The standard for determining custody is the best interest of the children, which could not be more broad, right? I mean, what does this mean? The law has established several factors that the court looks at when determining what the best interest of the children would entail. Quality of the home environment, parental guidance that the custodial parent provides for the child, the ability of each parent to provide for the child's emotional and intellectual development, the financial status and the ability of the custodial parent to provide for the child their basic needs financially, the relative fitness of the respective parents, and a big one is the effect that an award of custody might have on the non-custodial parent. So what that means is if the court believes that one parent is going to alienate the children from the other parent, that's a basis to deny them custody. It's very important to the courts that whoever is the custodial parent is going to foster the relationship between the non-custodial parent and the children. And that's a big aspect in custody determination. So playing the whole game of they're not involved, and then if you get caught that you're the one causing the non-involvement, you could lose custody. Okay. So how does the court measure these determinations and determine what's in the best interest? Well, first and foremost is if there's a custody dispute, a law guardian is appointed on behalf of the children. And a lot of times that law guardian is very, very important, especially if the children are of a certain age, that their opinion is going to weigh heavily with the court. I will say that there's no law giving a certain age as to when a child can articulate adequately, this is what I definitely want, and this is what the court is going to necessarily do. But I see young kids being able to persuade a court that they want to live with a particular parent, and here's the reasons why, and the judge making a decision based on that. Children as young as 12, 13 years old. For the most part, if a 16, 17-year-old is saying that this is what they want, the court's going to honor it, because you can't force a 16 or 17-year-old to live with somebody or do something that they don't want to do. A younger child, while like a 5 or 6-year-old, really shouldn't have that much sway with the court, and they don't necessarily. But I think that if a law guardian is presenting an opinion of the child even if the child is young, that they want a certain thing and here's why, and the law guardian says they're very articulate and they understand what's going on and they have provided adequate reasons, and the court is going to give that a lot of weight, which I think has its flaws for a 5 or 6-year-old to necessarily dictate where they're going to live and how often they see the other parent, but that's kind of where we're at. So kids' opinions matter. When there's mental health situations involved, sometimes there's a forensic appointed. Costs a lot of money. It's not something I love requesting or doing because it's just draining in the litigation emotionally and financially. But if somebody is alleging that the other parent has mental health issues that should impact the custody determination, that is something a court will order to help direct the court as to whether or not those allegations are true and to help the court determine custody ultimately. I would say that a lot of times custody issues are resolved eventually. Sometimes it is litigated heavily and then they come to a resolution. But I think eventually the parties realize that the judge does not care about them. They don't care about their work schedule. They don't care about their lifestyle. They don't care about the children's schedules, and they don't care about the children necessarily. All that they care about, I mean, they do care about the children to the extent of what is in their best interest, but ultimately what is best is a lot of times what the parties have determined the custodial arrangement to be, and the courts will honor that. And I think parties eventually get there. Sometimes they get there faster than other cases, but most of them do tend to end with a resolution on custody. So how do these things, how have they been impacted by the pandemic? Well, when you have dual households and kids going back and forth, obviously you have an issue with who the kids are exposed to because they're not under one roof. So some people in the last several months have utilized or have been accused to utilize the pandemic as a reason to withhold parenting time from the other parent. I had a case back in the late spring where I represented the father who was the non-custodial parent. He was a bus driver, so he's an essential worker. And the mother was refusing to abide by the parenting time schedule because he was out working and could be exposed, and she apparently wasn't very comfortable with, I think it was more than that, but she claims that she wasn't comfortable with the child going to see him because no idea what the child would get or bring back to her and her circle. The judge had none of it. She got angry at the mother for acting in that manner and basically said, how dare you dictate what was already ordered, going outside of that order and doing what you want when this man is an essential worker directed essentially to show up and work during a global pandemic. And because of that, he can't see his daughter. That's completely unacceptable. And it was not an argument that the mother had any chance in winning. And I have seen that time and time again with judges. They have no tolerance for utilizing the pandemic as a mechanism to deny parenting time, period. I even have a case right now. I actually represent the father who, and the mother left for Florida. She just up and left a couple weeks ago. He got an emergency order refraining the child from going outside of New York. So that was good. And the mother dropped off the child, but she herself went to Florida, which is fine. She's entitled to do whatever it is that she wants to do. And custody needs to be relitigated here, etc. Child is here, dad is here. We've had a couple conferences on this case because mom wants to see the child in Florida. And obviously, my client is not denying that that should happen, but his position is there's all these quarantine rules, and she's 5 years old, so who's going to financially pay for her to be transported back and forth to Florida? If she comes back from Florida, she is going to have to be pulled from school because there's quarantine and testing guidelines and all of that she's going to have to follow. The judge is like, I don't care. You're going to figure it out because parenting time with the mother is of paramount importance. So I have just seen time and time again that these judges are not tolerant of the pandemic being an excuse for, not really an excuse, but, like utilizing it in order to deny parenting time altogether. So anyway, that's that. There's also issues with homeschooling, right? So you have two different households and one parent is not doing the homeschooling and it's all falling on the other parent. So that's been an argument that's been utilized either post custody order or during litigation, that parenting time needs to be changed. Okay. Moving on to child support. The way child support works is that it is calculated based on income. When you have W-2 employees, it's easy, but when you don't, that's when there are issues and you have to look at the bank statements to figure out what their true income is, maybe their standard of living and the types of purchases they make during the marriage. What I also find is that in every single divorce, you have to fill out what's called a statement of net worth, which is a snapshot of expenses, assets, and liabilities. What so many people do and so many mistakes that the attorneys make, they fill out the statement of net worth and exaggerate the party's expenses and lower the person's income. So it doesn't make sense, right? And that is a big way that you can question people and even attorneys about their own client. This makes no sense. There's no credit card debt. Your expenses say that they're spending $90,000 a year and they make $70,000 a year. So technically 20 grand more should be imputed to your client because they're claiming that all of these expenses exist and they have the ability to pay for them because there's no debt. So that's something that a lot of attorneys even miss, and it can help your case pretty significantly. You have a W-2 employee. The only thing that gets deducted is FICA, Social Security, and Medicare taxes, and New York City if you're a New York City employee. No state taxes, no local taxes, no health insurance premiums. They don't look at your net pay. They look at your gross and deduct FICA, and the calculation goes from there. And that's it. That's what the statute says. In addition to child support, you can also get child support add-on contribution. So what does that mean? That means the non-custodial parent needs to pay a percentage of unreimbursed medical expenses and childcare expenses. Those are statutory add-on givens. Outside of that, the court could find that they could do discretionary add-ons. So they would have to contribute to extracurricular activities, educational expenses, and extraordinary expenses. College is an additional issue that I like to deal with in divorce agreements depending on the age of the children. If they're coming to be of college age, it should be in there so that you're not going back to court to determine that as an issue. Normally, what they do in agreements is that each party has to pay their pro rata share based on their incomes of college up to a SUNY cap. So if a child is going to Harvard or UPenn or some other expensive private state school, the law does not obligate either parent to pay for their pro rata share of that school's tuition. It's capped at the state SUNY rate. It could be any of the SUNY schools, Binghamton, etc. If the children even are almost of age, but not quite, like 14, 15, so they're getting to that age, and there's no agreement on college, the judge doesn't want to deal with it. They'll say, come back in a couple of years and we'll deal with it then, which is really frustrating for the parties because it's just not, I understand where the judges are coming from. They don't want to deal with it yet, but it's not that far away to restart litigation in just a couple of years to determine that issue. So how has child support been affected by the pandemic? Well, people's jobs have been affected, right? So the courts have had to deal with questions on how to determine whether child support should be deviated, because the way the statute is written is you look at your last year's tax income or tax return. So let's say someone's 2019 tax return says they make $100,000, but they've since lost their job or they have had to get a new job that makes significantly less money. Do they use 2020 income when they should be using 2019? Do they average them together? Especially if the other party is saying, well, they could be getting a job that earns them $100,000. They're just choosing not to in order to avoid this obligation. So those are the types of issues that the courts are grappling with currently. And this is if there's a current divorce going on and they're trying to determine some sort of temporary child support. And it's also for modification. So if there's a child support order in effect, a lot of the family courts have been dealing with downward modification petitions in order to allege that child support should be changed. Maintenance is very similar to child support in that there is a statute involved. It's based on income and it spits out a number. This wasn't always the case. It recently changed in the last 2 years or 3 years. But maintenance, or people know it as alimony, is basically support from the more moneyed spouse to the less moneyed spouse. A lot of times the argument is from the more moneyed spouse is that the other person never worked, never wanted to work, never tried to work. I paid for everything. Why do I have to now support her after the marriage? That was the reason for the downfall, blah, blah, blah. The less moneyed spouse says, I supported the household. I raised the children. This was a joint decision. I gave up a career. I gave up the ability and opportunity to work because he or she told me to. And now I'm stuck without any sort of marketable skills and no advanced degrees. And I'm unable to obtain a job that's going to be able to support myself fully. So what you would have is that these people were just constantly fighting with those two diametrical perspectives. And the law says, let's just put it into a calculation, just like we do child support. Let's figure out what these people's incomes are. And if they are that far apart where maintenance is spit out as a number, then that's going to be the presumptive maintenance figure. And this goes for temporary maintenance or permanent maintenance. So it's made it a lot easier to argue that maintenance should be something that is granted if the statute, calls for it. But there's also deviation factors and an ability to get away with not paying maintenance or get more maintenance than what the statute indicates because of certain the same factors that basically were in existence before the calculation was put into place. And the how it's been affected by the global pandemic, same as child support. The courts are dealing with modification petitions. They're dealing with maintenance should or should not apply because of X, Y, and Z, given the current state of affairs and the current economy, and this person's job is or isn't there, their ability to get work of equivalent income, etc. So I'm going to end with the question overall. I mean, so many people were saying back in the spring, you're going to have an influx of divorce cases. I would say it's definitely busy in the last few months. It's busier than it normally is, but I'm not seeing quite this surge in divorce filings yet. I think it's still premature. I think people are still in this pandemic phase and still doing the quarantining. And if there's going to be an increase, maybe 6 months to a year from now, we'll see it. Because a lot of times the reasons for a breakdown in a relationship, it festers. And so if this is going to be something that causes the downfall in a relationship because other issues are exacerbated, such as the financial issues, then I think we're going to see it later and not quite yet. So time will still tell. I will say that one big thing that has changed in the court now that we are almost 100% virtual. Some courts are allowing in-person appearances, but I personally have not been back to the court since before March. None of my cases have been in person. What the judges are seeing and what has been relayed to me in conferences is the increase in litigation has been absurd, not necessarily with divorce filings, but motions and written applications to the court have really gone sky high, and they are so behind because they have to work at half staff, which just recently happened. And this is part of my biggest pet peeve that I want to end on. I think that this is happening because virtual court appearances were something that attorneys would be able to make their business on, right? Because it would take a while. Now with virtual court appearances, your 2 to 3 hour court appearance have now become 20 minutes. And I think that this increase in litigation and the increase in motion practice is because of billing practices, to be honest. There's not as much of an incentive to settle as there might be if you are physically in court with your clients, just had a conference with the attorney, you're forced to tell your client or you just had a conference with the judge, you're forced to tell your client that this is the position of the court in order to get something resolved. And without that, it's becoming more and more difficult to settle these cases. So that's something that has definitely been a highlight, which has both been relayed to me and something that I personally have experienced in my cases dealing with my adversaries. I hope that that changes because it is something that drives me completely nuts. Because like I said, I want to get to the finish line. I want to get to the finish line creatively in the best way that gets my client what he or she deserves under the law, but also allows them to turn the page into this next chapter. And the increase in litigation does not allow for that. Sometimes it's necessary, but not all the time. So with that, I will end. And if there's any questions, I will take them.